Welcome everyone to session 13 of Thomson Rogers webinar series. My name is Lucy Jackson and I will be your host today. Today's topic is when and how to take legal action. This is a very big topic. There are entire law school courses taught on this, so this is going to be a bird's eye view on this topic. But it came up because we get asked this often by potential clients, so we thought we'd cover this in our webinar series, kind of a basic overview, if you will. Before we start today, we'd like to remind everyone that we are continuing our prize draw this year, and we'll offer one $50 Everything card to a lucky winner at each session. The Everything card is a gift card that you can redeem at almost any place you can think of. So at the end of today's session, we'll pick a random number and correspond to the order of how you registered. Be sure to stay until the end to find out who the winner is, because it could be you. Regarding the Q&A, if you have any questions, we ask that you please submit them using the Q&A button at the bottom of your screen. We will get to all your questions at the end of the presentation. We are also implementing a new thing this week where we are going to be asking you some questions. So at the end of the presentation, we'll have some poll questions for you based on topics covered throughout the presentation. So be sure to listen carefully. So with that, I'm going to start us off with limitation periods and notice requirements. And just as a baseline as well, myself, Craig Brown, and Stephen Birman are all presenting today, and our presentations will be focused more towards personal injury type civil claims. And of course, there are all other issues, but given Thomson Rogers' expertise, that will be where most of our examples are taken from. So for limitation periods, if someone is injured in a motor vehicle accident and they want to pursue a lawsuit to claim their damages from the at-fault party, they must file a statement of claim with the court. In Ontario, there is a standard limitation period of 2 years from the date the claim was discovered, at which time the claim must be issued by. So this means that the person injured in the accident must issue or file their statement of claim with the court no later than 2 years from the date of the accident. So for example, if the claim is issued 3 years after the accident, it's likely that the defendant or the at-fault party is likely going to bring a motion to have the claim dismissed because it's statute barred. There's some exceptions to this standard 2-year limitation, and I'm going to just touch on a few that we see most often. So for example, in situations where a minor, so a person under 18 years old, is injured in an accident, the limitation period does not start running until they turn 18 years old, or once they have a litigation guardian. And a litigation guardian is someone who can make legal decisions on their behalf. This is the same for an individual who is considered incapable. So for example, someone who does not have legal capacity to bring a claim by reason of a mental or a psychological condition. The limitation period does not start running while that individual is incapable or until they have a litigation guardian. Another exception to the standard limitation is in cases of sexual assault, where there is no limitation period. And as well as the standard limitation period, we also have what's called an ultimate limitation period, and that's of 15 years. So even if you don't discover you have a potential claim until 16 years after the alleged act or omission, you are unfortunately unable to issue a claim with the courts because of that ultimate limitation period. With respect to notice requirements, under some legislation, there is a requirement to put the defendant, so the at-fault party, on notice of your intention to pursue a lawsuit against them. So notice requirements are different from the limitation period because you don't have to file anything with the courts. However, there are normally specific requirements for how the notice is made and who you must serve the notice on. So in personal injury cases, we deal with a very important notice requirement quite often, and that's with respect to accidents where a municipality or the City of Toronto, for example, is potentially at fault for their failure to keep a road or a sidewalk in a state of proper repair. So for example, in a City of Toronto case where an individual slips and falls on an icy sidewalk, there are notice requirements. And that notice requirement with respect to municipalities, so including the City of Toronto, is 10 days from the date of the accident. So the 10 days after, within 10 days from the date of the accident, you must provide the city or the appropriate municipality with notice of your intention to pursue a lawsuit. That notice must be in writing, it must be sent by registered mail, and it's supposed to include a brief description of the injuries you sustained, the date, time, and location of the incident. Normally, this very strict notice requirement was only something we had to deal with regarding municipal accidents. However, as of January this year, there is now a 60-day notice period for slip and fall accidents caused by snow or ice on private property as well. So although these seem like very short periods to have to give notice to the defendant, there are some exceptions. So for example, if you have a reasonable excuse for not being able to give the notice in time and the municipality is not prejudiced, then you may still be able to proceed with your claim. Okay, now kind of starting from the smallest level of actions, small claims court is at the bottom. And so these are when you're pursuing a claim for damages, where your damages are assessed at $35,000 or less. And this recently increased, so as of January 2020, so prior to that, it used to only be $25,000, but now it's $35,000. And so these are if you're pursuing a claim for property damage or personal injury, where your damages are assessed at less than $35,000. Another type of claim that you may pursue in small claims court would be if you have money owed under an agreement. So for example, this may be something that a lot of our viewers right now may deal with for an unpaid account on a goods or service that you've provided to a client. So for example, maybe there's outstanding $5,000 that you haven't been able to get payment for. You could issue a claim with the small claims court to try and collect that $5,000. And how to start as a claim in small claims court. The court was established to be much more accessible for individuals and much easier, so more a simplified process rather than the more formal tort route. So individuals pursuing a small claim aren't required to have a lawyer. It's supposed to be simple enough for any individual to be able to do. But like a tort claim, you draft and file your claim. There are certain filing fees associated with this. You can do it all online. It's through the Service Ontario website, actually. And then the process of a small claim is very similar again to a regular tort claim. You have to serve it on the defendant, you attend the mandatory settlement conference, and it can even proceed to trial. So the next step up from a small claim is what's called the simplified procedure. So the simplified procedure is actually under our regular civil rules. However, therefore, claims where the damages are assessed at $200,000 or less. And again, this also recently increased. So in January of 2020, it was only for damages assessed at $100,000 or less. So you can proceed under the simplified procedure if your damages are assessed at less than $200,000 and there is no jury notice filed. The benefits of proceeding through the simplified procedure is that it's supposed to be a more expeditious route for individuals to proceed with their litigation. And as such, some of the benefits are associated with that. So for example, there are several features for simplified procedure actions that help promote a faster way through court. So for example, there's a maximum of 3 hours of oral discovery. This is compared to the 7 hours in a regular tort claim. If you proceed to trial under a simplified procedures action, the trial is limited to a maximum of 5 days. This can be a huge contrast to regular tort claims where we've seen civil trials that can last 2-3 months. Another benefit of the simplified procedure is the fact that there is no jury allowed. And I say that because in a lot of personal injury cases, we see juries actually make quite low damage awards. And so this may be a benefit in these types of cases. Limitations of simplified procedure, again, not having a jury could be seen as a limitation depending on the type of case that you're pursuing. Another limitation is the damage award, so you're limited to that $200,000. If you do proceed to trial and your claim turns out to be valued at more than $200,000, there are some cost consequences. So for example, even if you are successful, your legal costs, you may not get your legal costs, and you may have to actually pay part of the defendant's costs. Another limitation is cost. There's a cost award cap, so you can't recover more than $50,000, even if your costs are more than that. And there's also a cap on the disbursements that you can spend or recover of $25,000. So that's a very bird's eye view of these legal processes. And now I'm going to hand it over to Stephen Birman, who's going to go the next step up for us.
Thanks, Lucy. I'm going to just go back to the last slide. Not sure how I control the slides, but I'm going to talk about tort claims and the ordinary procedure. Under the ordinary procedure, which most of our claims come under, there is no monetary limit. There is a right to a jury, as Lucy mentioned, and we are dealing with the ordinary regular 2-year limitation period for the most part, especially in most of our motor vehicle claims. You always know when the date of the accident was, or should know, and you need to issue your claim within 2 years of that date, generally speaking. With minors, limitation period doesn't start until they're 18 typically, but assuming we're dealing with a 2-year limitation period, the question becomes, what a lot of our clients have, and some of you may have, as you're watching and the claims develop from the sidelines, is when do you actually commence these claims? Just because you have 2 years doesn't mean you have to wait 2 years, and that really becomes a strategic decision that we usually make as lawyers. There's different considerations that go into when you actually start the claim. And I'm just going to go over a couple of them from my perspective, things that I usually am thinking about. So number one, I'm often thinking about, is there a way of avoiding starting a claim? Is there any pre-claim settlement potential? Not every claim is made for a lawsuit and getting into litigation. So really understanding the client and what their needs and motivations and goals are, understanding the nature of the claim. Is it one that would be better resolved with an insurance adjuster that may not necessitate the involvement of defense lawyers and protracted litigation and those sorts of things? So I'm always thinking about that. Sometimes pre-litigation potential makes sense in more modest cases where it's not necessarily economically sensible to get into the protracted litigation, but sometimes it makes sense in the very large claims too, where we can sometimes convince insurance adjusters to pay their full policy limits. And if you're getting the full policy limits, then what's the sense of protracted litigation? Doesn't help anybody. In order to do that, though, you really have to understand the file and the case up front and be able to persuade the insurance company that it's not worth hiring a lawyer. It's not worth fighting this one through the courts, because you're going to end up paying all you have anyways. Another consideration that goes into when to start the claim, and especially in motor vehicle cases, is the threshold. Is there permanent and serious injury? Always a question in those cases, and that's typically a good reason to wait. So if you're wondering, well, why didn't they start the lawsuit yet? Well, why are they waiting a year or 18 months? Oftentimes we're waiting to get a sense of what is the permanency of the injury, what is the likelihood of the client potentially returning to work or not returning to work. Because once you start the lawsuit, you're in it. And I always want clients to know and really make sure they understand that threshold question, because it's really going to impact their claim going forward. So that's something we're considering as well. We're also always considering, do we know who to sue? You don't always know who to sue on day one. Sometimes you don't know who to sue even after 6 months or a year. Sometimes you learn new things through accident reports, police files, and just different types of investigation files. And it's nice to avoid situations where you sue one party and then you learn about other parties and basically are back to the drawing board, starting new claims or adding parties to claims as well. So there's no magic answer to when to start the lawsuit claim. I can tell you that when not to start it is 1 year and 364 days. into things when you have 1 day left and you're scrambling to put together a claim and figuring out who to sue. But beyond that, it really does become a judgment call. And it's something that I know I'm having ongoing conversations with my clients about, in terms of whether to sue and when to sue and what strategically makes the most sense for their claim. And I think that's an important factor as well. And I say that in the context of both tort claims and lat claims, which I'm going to get to on the next slide. If I can get to the next slide. Really knowing the client and what their objectives are. What is their appetite for litigation? What is going to be best for them? I mean, it's very easy to start a lawsuit and to start all sorts of lat disputes and to have 4 or 5 fights going at one time. But, does the client have the capacity and the wherewithal? Do they want to be involved in all these different disputes? Is it in their best interest from both a monetary perspective, but also from a psychological and recovery perspective as well? All of those things matter. And as I talk a little bit about lat disputes, which are similar to lawsuits in the sense that you have 2 years to sue, 2 years to start a lat dispute, similar type of litigation timetable there. I've recently written a blog, short blog that's on our LinkedIn site. Check it out, log in. There's a plug for reading our blogs. And what I've said is there's a threshold question of, especially when you're talking about lat disputes, is there a potential to persuade the adjuster to change their mind? Because litigating lat disputes over treatment plans is not the most constructive thing to do. The client obviously needs treatment. That's why the treatment plan was put in. And fighting about a treatment plan is both not financially sensible for the most part, not practical in a lot of cases when it takes or can take a year or more to get to lat hearings and 6 months to a year or more to get to lat decisions. So I recently had an example of a client who was very, very upset about a denial, and I often do this. I advocate with the adjuster and sometimes get a supervisor involved. And if you're going to do that, you have to be prepared. You have to really read the reasons for the denial, read the IEs, find the frailties in them up front so that you're not arguing about them at a lat hearing. You're pointing out these issues early on so that they can, make it easy for them to change their mind and reverse course. But in this particular case, the client herself was so distressed about the assessment and the denial. She wrote a letter to the adjuster. It was heartfelt and compelling, and the adjuster changed their decision in 1 day in that case. But I'm not suggesting that it's always easy to make that happen, but it's always worth a try when dealing with lat disputes. Another consideration with lat disputes and catastrophic claims and settlement, there's a timing issue associated with these disputes. If you resolve accident benefit claims before tort claims, the tort defendants use that and they take a credit of those amounts, and it often makes it more difficult to settle tort claims or to get the proper compensation in tort claims. So that's a consideration as well. If we are filing lat disputes, we also have to really consider what we're filing lat disputes for. We have to be practical. We can't be filing a lat dispute every time there's every denial on every issue. I mean, I'm just being honest and upfront, and it's a hard thing to tell clients because I know it can be really frustrating when so a modest expense that's really important to them is denied. But we have to be practical about these things, and we need to make sure that when we're starting these disputes, it's sensible for the client and for the process as a whole. And I'll just give an example of a practicality issue. Me and Lucy have a lat hearing that's starting in 2 weeks over a catastrophic impairment issue. And this is a file we took over from another law firm, so we don't take the blame for this, but included in the application was 50 or 60 different denials of different treatment plans, most of which were denied because funds had been exhausted. So we've decided to focus our hearing on the catastrophic impairment issue, knowing that if we're successful on that issue, we can come back and deal with all those treatment plans later on. And that's going to save us days and days of hearing time. It'll save the client all sorts of stress. It will save all sorts of costs as well. So the last point I just want to make on both of these, I've made it already, but I'll just make it again. When starting these claims, don't forget about the client. Don't lose sight of the client. I always involve the client in reviewing statements of claim, reviewing lat applications. I think it's very important that clients understand when they're in litigation, what that means. At the end of the day, it's their name that's on a statement of claim. And once the lawsuit or lack claim is going, it's going to bring certain obligations and sometimes certain stresses to them. So it's important that they know that up front and they're not learning about that, say, the day before discovery or the day before a LAT hearing. And with that, I'm going to turn it over to Craig Brown, who's going to take this conversation to the next level and talk about more complex class action and group action type claims.
Thanks, Stephen, very much. Good morning, ladies and gentlemen. I'm going to talk about mass tort and class actions, and you might think that those are different things, or perhaps are related as different kinds of claims. But in fact, I like to think of them as both being related to cases where many people are injured or harmed by the act of one or a few defendants. And so the mass tort is in fact the problem. The mass harm is the problem. And the class action is actually the solution to that problem. Class action is a process for grouping the claims that have arisen out of that particular event. Now, I'll give you an example from Thomson Rogers' sort of corporate experience and my own. I articled at Thomson Rogers in 1979, which is before most of you were born. And on November 11 of that year, the greatest urban evacuation in North American history took place. A CP train was derailed in Mississauga at Mavis Road. It was pulling cars of hazardous chemicals and explosives, and they caught fire. And 200,000 Mississaugans were moved out of their houses for 3 days. Happily, it was actually called the Mississauga Miracle because there was only one injury. That was Hazel McCallion, who was the mayor at the time, who sprained her ankle when she was looking at the wreck. Thomson Rogers issued claims arising out of that incident against CP. And I was here at the time. This was before class actions. We issued 5 statements of claim, and we named over 2,000 people in each of the statements of claim. So what's called the style of cause, or the list of the parties to the litigation, in those cases was over 25 pages long for each of those claims, because we had to list each individual business and person as a claimant. And those are in the days of the IBM Selectric typewriter. So it was cumbersome is an inadequate word to use to describe dealing with that many claims. The statements of claim themselves were a logistic nightmare because they were 1.5 inches thick. So the other problem is that theoretically, each of the plaintiffs in those claims was responsible for the costs of the litigation if something went wrong and if we weren't successful. So it's discouraging for people. And each of them probably didn't have very big claims, and they wouldn't have pursued the claims themselves if they'd had to do it individually. In 1992, the Class Proceeding Act was passed. I don't know whether it was in response to Mississauga or because it was we were following the American trend. But in class actions, groups of claimants can form a class of people through a process called certification. There are 5 simple criteria for certification. You need a cause of action, you need a wrong, you need an identifiable class, you need some common issues, things that are in common to all the people in the class. It should be the preferable procedure, meaning better than a workers' comp hearing. And you need a suitable representative plaintiff. And why was that important? Because the representative plaintiff manages the case for the class and takes responsibility for costs. So the people in the class do not bear any risk of adverse costs or bad consequences. There's only an upside for the people in the class. Now, shortly after that act was passed, I began getting involved in class actions. And an example that Thomson Rogers was lead counsel in is the Indian Residential Schools case. We issued the claim in 1999. That was Baxter versus Her Majesty the Queen. And it ultimately incorporated a class of 80,000 or over 80,000 surviving residential school students and 38,000 sexual and physical abuse victims. So imagine how that is a mass tort. It's also a case where class action, the class action procedure, was really the only way that those people were going to achieve justice and get access to justice and compensation for what had happened to them. So that's mass torts and class actions in 4 minutes. And I'll turn it back to Lucy or Stephen.
Great. Thanks, Craig. Thanks, Stephen. I think at this point, we're going to bring up our questions for the audience. So I'm going to get some help from our tech to bring up the first poll question, please. Okay, great. So the first question is, what is the standard limitation period in Ontario? Give everybody a few seconds to answer. Okay, good job, everyone. 2 years, that's right. Okay, we'll go on to the next question. And also, if anybody has any Q&As as well, you can put them in and we'll get to them after we go through these questions as well. So we'll go on to the second question, please. So how many days does a claimant, so an injured person, have to put the city on notice for an injury claim on a sidewalk? So yes, the correct answer is 10 days. And so that's for any city or municipal claims where you're alleging that there's a failure in keeping the road or the sidewalk in a state of good repair. And remember that for private property now, where there's a slip and fall involving snow and ice, there's now a 60-day notice requirement that just came into force at the end of January of this year. Okay, we'll go on to the third question, please. So what is the monetary limit of small claims jurisdiction? Right, so yes, majority got it here. So $35,000 is the maximum amount you can claim in small claims. The maximum that you can claim for a simplified procedure claim is $200,000. And then remember, for a regular tort action, there is no limit on the damage amount you can claim. Let's go to the next question, please. This one may be a bit tricky, actually. Which of these issues would not be subject to a dispute at the LAT, so the License Appeal Tribunal? And yes, everyone got that. That's liability. And our last question, please. How many certification criteria are there for class actions? So,
Wow.
job. So yes, that's 5. And that's what Craig went over in terms of the common issues, proper representative plaintiff, and so on. All right, so thanks everybody for participating. I don't see that we have any questions here in the chat. So with that, I think we can select our winner. So Craig, I believe you have
I have the magic bag full of
magic
little
bag. Perfect.
gads. Actually, I see that all of them have the number of 26 on them. No, just kidding. I'm going to mix them all up. There's one for every participant, and I'm pulling out a yellow one that says, can everyone see that? 33.
33. Okay, and the lucky winner is Lori Eisen. Lori Eisen, you are the winner. So one of the members of our team will reach out to you to find out the best way to forward you the digital everything card, Lori. So thank you. And thank you everyone for joining us today. Be sure to look out for the next Thomson Rogers webinar session in May. More information will be provided on our website. So thank you everybody and have a great weekend.